Morning. This is Senate Judiciary, second edition. And we're taking up S-184, a bill having to do with justifiable homicide. We have a strike all redraft by Eric Fitzpatrick. It's draft 1.1. Eric, do you want to walk through the changes, please?
Yeah, sure, will do. Good morning, everybody. It's Eric Fitzpatrick with the Office of Legislative Counsel, here to walk the committee through the redrafted committee strikeout version of S-184. It's an act relating to self-defense and defense of others. Senator Zeus, you want me to pull up the language real quick, or? I think he might have frozen there.
It's easy to read, and I don't think we need to pull it up.
Okay, great. So you'll see there's two changes, and the bill essentially deals with, as I'm sure the members all remember, that it's clarifying some legislation that the legislature and this committee passed last year, to be clear that when you made amendments to the self-defense justifiable homicide statute, you did not mean to remove the ability of a person to raise the defense of others. So in other words, not just the self-defense defense, which is clearly preserved, but also to make sure that defense of others, which is a defense that was available at common law, and I don't think anybody intended to override with the changes that you made last year, just to make clear that that's not the case. So there's not a change to that piece of the bill. That's the middle subsection of the bill, which just makes clear that the defense applies when you're defending yourself or any other person. And then similarly, a similar change is in this strike-all amendment is proposed to be made to the first piece of the bill, the first defense provision. I'm just pulling that up right now. And the idea there as well, you see that there are listed relations. In other words, members of a person's family and others for whom a person can raise that defense, and it's expanded to include any person, essentially. So I'm going to pull that up right now. I actually don't have it on the screen, so give me a moment. Because I had. Right. So you see in subdivision A1 is where that change is proposed to be made, that that the person is guiltless of killing or wounding another person. The existing statute provides in the just and necessary defense of the person's own life or the life of, and then there are specifically listed other persons whom the person could defend and be justified in that defense. And that's existing statute. That wasn't changed. Well, I shouldn't say that. There were some technical changes made to that language in the bill last year, but substantively no changes other than taking out, you may recall, that I think master and mistress were in there as well. And that was struck because that's archaic terminology that you no longer use, but otherwise no substantive changes really to this provision. But the proposal here is to also provide that just and necessary defense applies not only if you're defending one of those individuals, in other words, the person's spouse, parent, child, sibling, guardian, or ward, but rather it would apply for the just and necessary defense of any other person. So that's the proposal for that first piece. And the second change you'll see at the very end of the amendment, that actually comes directly out of the existing aggravated assault statute. Similar language is there, and that's to really clarify the same point that I mentioned earlier, which is that the intent here with any change that you make is not to limit or infringe or overrule or and otherwise negate any defenses that a person would have at common law, because it's conceivable that changes that the legislature makes could be interpreted that way. It could be interpreted to mean that, oh, these other common law defenses are no longer available. And that's exactly the concern for, you were trying to address with the middle part of the bill, to make sure that you're not inadvertently overruling the common law defense of others. So this just makes that point clear, and it's done elsewhere in the statutes as well. So it's I think familiar to the courts.
one question, Eric. In the bill was introduced, there was section 1 had 2305 justifiable homicide, the 1, 2, and then a 3, which was in the case of law enforcement officer. That's been taken out of this draft. Is there a reason for that?
No, I think the 3 is still in there. Do you mean the law enforcement officer at the bottom of page 1, lines 19, 20, 21?
Yeah, it's not in the draft 1.1.
Yeah, it is.
Is.
Not the one I just printed out.
Maybe the printer, maybe your printer cut it off. It's in mine.
It's in what I'm looking at.
Then what I'm looking at.
Well, let me look at my copy that I just pulled up off the web page. It's all entirely possible that my printer is as unstable as my computer is. No, my copy from the web page does not have 3 in it.
Let me make
Oh,
sure
yes,
I-
it does. Wait a minute, it does. It does. For some reason, it didn't print. Oh, yes, it does. Yeah, I'm sorry.
No, that's
I
okay.
apologize. You
No, I'm
used,
glad you made sure.
yep, no, it does. Okay. Scratch that question. Reread it wrong.
Thanks.
Any other questions for Eric?
Actually,
Senator Benning?
this is actually for Eric and for Senator Baruth. I realize this is current language, but line 16, page 1, the words in the forceful or violent suppression. Exactly who is that referencing? Are we using the deadly force against a forceful or violent burglary? I don't see that as a clean stretch of language, and I'm struggling to figure out whether we should take the time to correct this.
That's not the way I read it.
Okay, how do you read it?
I read it, and I think that that language was changed in the bill last year. And I say changed, I think technically the placement of the language was changed. I don't think the intent was to change the meaning. And I think the meaning was and remains the forceful and violent suppression is by the actor, by the person, repelling the peril, I think.
Yeah, that's how I
Yeah,
read it.
actually, I'm looking at H145 or Act 27, and forceful and violent are underlined. So they were added last year.
But it was in I think it was in the existing law, it was struck. It was in the later part of that sentence, I think.
So, Eric, if I can be clear in my understanding, you're looking at those words forceful and violent and applying them to the person who is using deadly force to repel a burglary. You're not looking at that language as a burglary that is being committed in a forceful or violent way.
That's the way I'm reading it. There may be other readings. I'd be interested to hear how other folks are, but I think that's the way I'm reading it.
I mean, if you take out forceful and violent, I'm not suggesting that we do, but just as a thought experiment, if you just say in the suppression of, it's pretty clear. So it's describing how you would suppress somebody who's threatening someone else imminently. That's how I read it.
So
Right.
Although
in the case of Arbery, forgotten his first name, in Georgia, the allegations from the defendant were that he was committing a burglary. But a clear reading of the video was that he was not doing, even if it was a burglary, he was not doing it in a forceful or violent manner. And I'm trying to figure out, we've already given the actor in this particular section authority to repel with deadly force. Why are we repeating forceful or violent? If it's, I'm just trying to make sure we're all on the same page.
Okay, well, act,
I understand deadly force is forceful and violent. So if you're applying it to the actor, that's one thing. But was our intent to say somebody in Arbery's position would not entitle an actor here to repel with deadly force?
Joe, in the original Act 27, the language that was added was forceful and violent. The other stuff was also added, but in this particular, in the forceful or violent suppression of a person attempting to commit murder, sexual assault, aggravated sexual assault, burglary, or robbery. And what was struck was with force or violence. So whatever reason, we took the force or violence, changed it to forceful or violent suppression in front of that. So does that make sense? I'm reading, so.
I understand, Dick, what we did.
No, I don't think, no, my point is that before it had read in the current law before this, it had read sexual assault, aggravated sexual assault, burglary, or robbery with force or violence. Semicolon robbery with force or violence. I think they wanted to make clear that it was with force or violence. And they moved the forceful or violent suppression to that front of the section. Does that make sense? Senator Baruth, yeah. I think they're getting caught in the weeds.
I see Joe's point that there's, it looks to me to be unnecessary, honestly, to say forceful and violent, because we're already, as he said, we're already granting that they can repel with deadly force in the suppression of a person attempting to commit these things. So I suppose one possibility is you could strike forceful or violent. I do think with this, this particular section seems to be a kind of black hole that we can't get out of. And what I worry is that this draft is very clear, very simple. And I worry that we're going to make another change. Then the House is going to want to revisit it next year. So the only thing that I oppose is constant revision of justifiable homicide. So
Yeah.
I could either go with striking forceful and violent or leaving it alone, but I would hope that we wouldn't pick it up again.
I understand the frustration. If everybody else is reading this as just fine, I'll step back. But I question the wisdom of why that language is in there. And
Well, we're
leave it at
lucky that Evan Meenan, representing the state's attorney, and Matt Valerio, representing the Defender General, or is the Defender General, are here and may wish to comment on the changes as well as Senator Benning's concern about forceful and violent. Who wants to go first? Evan, go ahead.
I suppose I'll be the lucky volunteer. This is Evan Meenan from the Department of State's
No,
Attorneys.
you unmuted first.
Oh, lesson learned. It's interesting because I remember we had a bit of a conversation about this at the last hearing, and I read the new draft of the bill, and I was having an internal debate with myself about whether to ask the exact same question that Senator Benning did, and the side of me that that wants to not complicate this further was prevailing, and I wasn't going to say anything. And then Senator Benning raised the issue, and I think it's perhaps a good question to ask. I think I think one legitimate reading of the language that exists in the current bill is that, you know, there's really a two-tier inquiry. The first would be whoever is repelling these offenses needs to first be justified in using force or violence to do so, because that's sort of one question, because that could be something less than deadly force. And then the use of deadly force also needs to be justified itself. But at the same time, some legislative language that I had sent to both Senator Benning and Eric Fitzpatrick and read burglary or robbery with force or violence. Basically, it eliminated the comma that used to appear in this statute to make it clear that the burglary and the robbery had to be committed in a violent way. Otherwise, you can't just go up and use deadly force. So, you know, could some added clarification be helpful? Perhaps. But I do think the language in the proposed bill is pretty good, especially with the addition of the comment about common law.
Matt?
I was actually, I'm in favor of like not changing this. What this tried to do was incorporate the prior understood language involving defense of, defense of others, and the prior justifiable homicide statute, which was derived from common law, that there's been a lot of case law and an understanding of. Now, we don't get a lot of these cases, but this goes back, literally hundreds of years. There's a common law, right to defend your own home, where you no longer have a duty to retreat in your own home, and the like. And that is kind of incorporated into this. And all of the way these have developed is on a case-by-case basis, but it's understood. I'm worried that if you take out some of this language that has been in there for quite a number of years, that a court might look at it and say, oh, they're trying to change something substantive. And I think that what you're trying to do with this bill is actually maintain what has always been available at common law. And courts look at things oddly, and at times when language that has been around for a long time changes. And, I point no further to, Judge Treadwell's interpretation of the midpoint review, which has been around for a really long time, but there was a, minor change in the criteria for which it is, and then all of a sudden it wasn't retroactive. I didn't understand the opinion. I've told him that, but I just worry about what a court will do when you start changing language that has been there traditionally, because they're going to infer that there's some sort of intent to change the law as opposed to clean it up because it was old. I'd leave it alone.
Thank you. Senator Benning.
Sure, I'm hearing and I'm digesting. This is my bill. I don't want to screw it up. The phrase is something we actually moved. It's been language, it's been there for 100 years, but it's a phrase that we moved. And as I read it, I come up with a question. If everybody from the state and the defense is satisfied with it, and nobody on this committee is looking at that saying that's an awkward piece of English language, then I'm just going to end it there and we'll move on, because I want the bill to pass.
Okay. Well, the fact that we moved it from where it had been last year in Act 27 signifies that and I don't remember the reasons for moving it, but I know we did. So I would favor leaving as is, and much probably for the reasons that Matt just suggested. I just would say that as a co-sponsor of the bill, Senator Benning, along with Brock, Chittenden, Collmore, Cummings, Ingalls, Lyons, McCormick, Nitka, Parent, Burchuk, Starr, Terenzini, Westman, and White.
Oh, am I on this one?
Yep.
Yes, this is actually the only bill I've submitted with a quorum of senators attached to it. So I'm very happy with that. And I'm not trying to extend this conversation by any stretch. The question has been answered, and I'm happy to move on from there. We'll leave it be.
All right. So are there any other further questions or comments about draft 1.1? Hearing none, is there a motion to report to amend the bill as seen in draft 1.1, 121, 12:23 p.m.
So
Senator
moved.
White has moved that we report the bill report that we amend the bill S-184 as seen in draft 1.1. Any further discussion from anyone? Hearing none, Peggy, would you please call the roll?
Senator Benning,
Aye.
Senator Nika,
Aye, yes.
Senator White,
Yes.
Senator Baruth,
Yes.
Senator Sears,
Yes. All right, it's been amended. Now the question is, shall we report S-184 as amended favorably to the full
Sure.
Senate? Senator White has moved that we report S-184 favorably as amended. Any further discussion from anyone?
My only comment would be that Senator Benning reported.
I think that's probably a given.
I thought Jeanette was jumping out there to make that effort herself. So
Oh, no.
I'm happy to report.
Okay. So Senator Benning, excuse me, Senator White, we have to vote first before we can
Okay.
decide who reported is. Peggy, could you please call the roll again?
Senator Benning,
Yes.
Senator Nika,
Yes.
Senator White,
Yes.
Senator Baruth,
Yes.
Senator Sears,
Yes, so we're unanimous in that. Senator Benning, would you like to report this bill?
I'd be happy to, Senator Sears. And can I ask Peggy, how do I get this up to Senator Bloomer? Or
I'll send you I will send you an email telling you to reply all.
Thank you.
Really rather simple. All right, one other matter.
It's still, don't send that document though. That needs to.
Yeah, I'll wait for you to give me the clean version, Eric.
Eric.
Yeah. Thank you.
I will need a list of witnesses.
Yep.
And Eric, don't worry about a summary. I can handle this one.
Okay, thanks.
I'll get you the witnesses.
On S-113, the PFOA bill, we had a third amendment. I think I sent out an email, but I hope everybody's okay with changing the date from effective date from July 1, 2021 to July 1, 2022. And that would be the third amendment to the bill. I
Yes.
guess not
There was
problem.
Can I just say something about that? You know, that came up when we were doing the walkthrough, and for some reason, Mike O'Grady had some comments about it, about maybe leaving it at 21. I have to admit, I had a big question mark by it. I mean, I'm fine to change it, but why did he question it in the beginning?
I don't know.
I don't remember that.
I didn't realize he did. I missed that part.
We did have some discussion about it briefly.
Yeah.
But
I think
So
it,
Senator Sears, do I need to do anything on that, or is that going to be like an amendment on the floor?
I think Michael has it ready for the floor. Could you just check with him? Because right now on the calendar are on the notice calendar are two amendments. The two we adopted at the third.
All right, so I don't think I need to do anything because we've already sent the
No,
way
if
we
you would
voted it
just
out.
if you would just send a note to Michael Grady, asking him to send that amendment to the secretary.
Okay,
All right. Did
okay, I'll
we,
CC you on it just so I make sure that I say the right thing. I don't want to.
okay. The judge we interviewed last week, Judge Juron,
Giron.
we did not vote, did we?
No, we haven't voted on any of the judges. You said you wanted to wait
Okay.
till the end.
Thank you. Okay.
And we have
I
one more
woke
next
up-
week.
Okay, I woke up in the middle of the night wondering what we had done. All right, thank you for reminding me of what we had done. And so we're about 5 minutes early on our issue of judicial nominations and confirmations, but I think we could start. Judge Zone is with us. So, and as is our tradition, Judge Zone introduces the person, and then we ask the person for their comments.
Well, good morning.
Good morning, Judge.
It is my pleasure to be here this morning, Tom Zone, Chief Superior Judge, and introduce Judge Elizabeth Novotny to the committee. Judge Novotny is a graduate of the University of Vermont and the Suffolk Law School. Following law school, she worked with the Department of State's Attorneys. She then worked with Bill Sorrell's office as Deputy State's Attorney in Chittenden, where she was hired. Thereafter, she went into private practice. She again returned to public service as General Counsel for the Department of Public Safety for over a decade before moving over, again, continuing public service to a similar role with the Department of Financial Regulation. Most recently, she served as General Counsel for the Mosaic Learning Center, and I think many members of the legislature know her also from her time on the Hill dealing with legislative matters. She's active and engaged in her community on many boards and law activities. She's been a member of the Vermont Bar Association, the New England Bar Association Board of Managers, and she's actually a past president of the Vermont Bar Association. When Governor Scott swore her in and announced her appointment, he said that Judge Novotny was incredibly experienced and that she would bring to the bench her integrity, honesty, compassion, and impartiality. And I have had the pleasure of knowing Judge Novotny, not just after she got appointed, but I actually had matters I dealt with her on many years ago when she was with the Department of Public Safety. And I have no doubt that what Governor Scott saw in her as her as her characteristics and what she brings to the bench, she absolutely has. I've seen it, and I'm proud and pleased to introduce Judge Novotny.
Thank you, Judge Zone. I appreciate it. Welcome, Judge Novotny.
Thank you.
Really needs no introduction to this committee. I can't count the number of times you appeared before this committee on issues, whether they be with the state's attorneys, with the public safety, or as a lobbyist for various law enforcement organizations, so, and other groups as well. So maybe you could remind us a little bit about who you are and some of your background beyond just having attended the University of Vermont and Suffolk Law School.
Thank you, Senator Sears, and thank you, Judge Zone, for the introduction. I appreciate it. I should make one correction. I was actually hired by State's Attorney Kevin Bradley, and I don't know if Senator Benning remembers Kevin Bradley, but Kevin Bradley was the State's Attorney in Chittenden County. Before he was the State's Attorney, he was a Burlington police officer, and he was, I guess, infamous or famous for and known for his role in bringing down Paul Lawrence. Paul Lawrence was a drug investigator. He worked for many police departments, but he had essentially been planting drugs and falsifying testimony and evidence that led to a lot of convictions of innocent people. And it was Kevin Bradley, as a young police officer, who began to suspect that Paul Lawrence was a dirty cop. And as a result, there was, I think it was in his first year when he began to suspect this, and he immediately reported it to his supervisor, which launched then an undercover operation. The state's attorney then was Patrick Leahy, who you probably all remember and know. And Paul Lawrence was brought to justice, and many of those folks who were convicted had their convictions expunged appropriately. So I only mention that because for me, not only did it matter a lot to me that I was hired by Kevin Bradley, he was a man of great integrity. He was originally a seminary student, so he was also a man of great compassion. And so for me, he was a role model when I was hired by him, during the time I worked for him, and we continued a friendship that followed his departure from that office. I would say that for me, in my 30 years as a lawyer here in Vermont, you'll note that I have a range of experience because I never actually had an agenda to be any one particular thing. I didn't have an agenda to be in private practice. I didn't have an agenda to be general counsel for any agency. I didn't have an agenda or a goal to be a judge, in fact. For me, I'd say my career was really sort of a series of a path that led to a number of opportunities. I would open a door, make the most of that opportunity, and then there would be other opportunities that presented themselves. But in Chittenden County, which would be the state's largest and busiest county, I would say my formative years and were really there. The lessons about justice and compassion and fairness began there and were imbued there, and I carry them with me today. It was a tremendous experience for me that I really have never forgotten. And it started on day one in that job, which I kind of described a little in my application that I think you have a copy of. So I've been in many courtrooms. I've been in probate court. I've been before boards and commissions. I've done some federal work. I've done civil matters, criminal matters. I've represented criminal defendants. I've prosecuted criminal defendants. I've been an expert witness and a guardian ad litem in family court. I've done family cases, juvenile cases, a little bit of everything, which maybe makes me a master of nothing but a jack of all trades, so to speak. I think the cherry on top of the career was actually the legislative work, because I was exposed to that 50,000-foot policy consideration that you engage in every day as you spend time on these bills and think about, well, what ought to be the conditions for which people are incarcerated for, and what should judges be thinking about? So I have spent a lot of time in your committee rooms learning about what the legislature is thinking in terms of broad criminal justice and judicial system policymaking. And that has, I think, it's already given me the opportunity to speak up with other judges about why something is written a certain way, because I can bring that background to them. So that's sort of that 30-year wide-ranging legal experience that I bring on a personal level. I'm married. My wife and I have been together for, I think we're coming up on 25 years. We have 2 sons. And I grew up here in Vermont, decided to stay here. I returned back from law school knowing that Vermont was pretty unique, and I wanted to come back and make my life here.
Thank you, Beth. I need to interrupt just for a moment because I messed up. I used an agenda from that I printed out on Tuesday for today, and I forgot that we had added 166 at 11 a.m. So for those of you who are here on 166, I apologize. I'd like to reschedule it Tuesday morning as soon as we get off the floor, if Maria is available Tuesday morning. If not, we'll try to find another time. Okay, good. We'll schedule it as soon as we get off the floor next Tuesday, and then take up the S-254 after that. I apologize to those of you who came and, but you're lucky you listened to Judge Nutt. To her talk about her reasons for wanting to be a judge and all the things she's done. I thank you, Beth, and I'm going to call you Beth because we've known each other for years. We've agreed, disagreed, agreed to disagree on many occasions. I guess my major question is, does all your background with law enforcement, state's attorney, etc., how is that going to affect you on the bench in criminal cases? So if you'd like to answer that question.
Sure. Well, I'll state that, yes, I started my career as a deputy state's attorney in Chittenden County, and it was followed by a career in private practice where I did criminal defense work. So I've seen both sides of that equation. I'm just a believer that, and it is one of the reasons that I was interested in becoming a judge and applied for this job. I learned early on that the courtroom is really a community where pretty much everyone there working in that community, whether you're with restorative justice or diversion, or whether you're a criminal defense attorney, whether you're with the Department of Corrections, whether you're a judge or a state's attorney, doesn't really matter. I think everybody's got the interest of justice in mind. How we get there, or what the end goal ought to be, they may disagree on. But I learned pretty quickly that that everybody is working toward that end. For the defense attorney, that definition of justice might be very specific to a particular outcome or process that you want for your client. And for the state's attorney, well, for me, it was about the oath of office, which was to do equal right and justice, and that is similar to the oath of a judge. And that is not about conviction, but about doing justice in that broad way. It may actually mean not charging a case. I have seen law enforcement in that capacity as a prosecutor in private practice when I did criminal defense work, and when I actually was contracted to serve the Department of Public Safety in representing the department in a disciplinary matter against two troopers charged with excessive use of force. They asked me to essentially prosecute that case, but they contracted for that service. And when I was at public safety, where part of the job required us both to work on policy related to law enforcement, and as well the enforcement of their internal affairs code of conduct. So that work of prosecuting officers, so to speak, continued while I was at the Department of Public Safety. In my capacity as the lobbyist, if you will, for the police association, I was not involved with particular officers. I worked with a very small group, legislative committee, and they were focused on certain legislative bills that impacted law enforcement. Less so the weeds on the criminal justice bills, more so bills such as what would be the role of the Criminal Justice Training Council, whether we were going to license law enforcement officers versus just certify them. And I wasn't their attorney. I was their lobbyist. Most of those folks that, well, on the legislative committee, I will not see as a judge. I think there's only one chief who's still active. They're either retired or they're in roles where they aren't going to be actually working any cases. So what have I learned about law enforcement? Well, I've learned they're human beings. I learned that I don't have an ideological view of law enforcement, that they are all heroes or that they are all wonderful or they're all perfect. They're human. They have a hard job. And I understand, appreciate the challenges and difficulties of it. And I also believe that they carry a great responsibility. And with that responsibility, I think we hold them to a higher standard, and we should. I've never been shy about sharing that view with them throughout my career. They know I feel that way. And I suspect that as a judge, well, not suspect, I will say that as a judge, I don't have any predisposition one way or the other when it comes to law enforcement, because I have seen them do a great job and I've seen them make mistakes. So I'm actually probably more aware than anyone of the 360-degree experiences that law enforcement can have. And I don't carry any, as I said, any ideological or predisposed view that if you're a law enforcement officer, you will always tell the truth and you will always execute your duties perfectly.
Senator White.
So I thank you, and thank you, Beth. I just, Elizabeth, I am sorry. I just want to say that I have seen seen you in roles not only in this committee, but in government operations a lot as we dealt with law enforcement issues. And I found Beth always to be willing to look at all sides of an issue and try to come up with the best solution. She did represent her clients, but she also really understood where people were trying to go and was very collaborative in working on those issues. And I will not speak for the board at all, but I'm just speaking as my experience with the judge in a different committee and a different role, and dealing with law enforcement issues and other issues. I will say that when we did the wellness task force, I'm not even sure what it's called now, but Beth worked really, really hard on that to make sure that we got that passed and put in place, partly to honor Commissioner Baker for his longstanding commitment to the state, but just in general, her devotion and empathy for those frontline EMS workers was pretty incredible. So I just wanted to say that. No question.
And that was pro bono, by the way.
Yes.
Thank you, Senator. Yes, it was. It was a volunteer effort on my part. But thank you.
Thank you. Other questions for Beth or Judge Novotny, excuse me?
Now we can dispense with calling you either Beth or Elizabeth and just call you Judge, okay? That's going to be easier.
Well, I guess one question I have is your experience in civil matters. You've mainly been in criminal justice work. So are you a little worried about that, or do you have a background there as well?
I do have a background there. Thank you for that question. I was in private practice, and I think Senator Benning will appreciate this. It was an old-fashioned small firm, and they were a general practice firm, kind of a dying breed these days. To have practitioners do a little bit of everything, you do still see it, but I did a little bit of everything. I did real estate transaction work. I did some municipal law. I did probate law. I did family work. I did some social security disability cases and criminal defense cases. I was a little bit of everything, whatever came in the door, basically, we did. One of the practitioners did a lot of transactional work for small business clients, so I did some of that work as well. And, at public safety and financial regulation, at the end of the day, they were both state organizations, and at the Mosaic, which is also an organization, when you are representing an organization, that is general counsel work that, you could be working on a lease, you could be working on a contract. I'm doing that actually more. All I'm doing at the Mosaic was a lot of civil work. Much of it related to just the operation of a business, and some of it related to education, which was the actual purpose of that organization. That civil work continued throughout my career.
Good. Thank you. Senator Benning.
So Judge, where are you going to be assigned?
Well, I am currently assigned to Chittenden, where I'm doing some criminal cases 2 days a week. And I'm up in Franklin County, where I will be doing the family docket.
I laughingly suggested to Judge Giron last week that I would see him in court. And the committee doesn't know it, but I actually did see him in court earlier this week. And I will confirm Judge Zone's impression that he is calm, cool, and collected. I was happy to see him on his first day. So good luck.
Thank you. Thank you. Well, I've
Thank you.
had the pleasure of training with Judge Gray, Judge Giron. We're like the three musketeers getting our training, and it's been a pleasure to get to know both of them. They really are very nice, and everything that was described to you, I also have experienced with them.
Good. I don't have any other questions. I just, I'm glad that you got your appointment. I'm sorry that your appointment is occurring in the middle of a pandemic, which probably makes it much more difficult to.
Yes.
And when you said Franklin, I said, oh my God, that's probably where the biggest backlog may be. So all of our best to you in trying to work your way through this. I can't imagine starting a new job in the middle of all. I was thinking the other day that somebody mentioned a House member whom I've never met. And evidently they were elected 2 years ago, and we've been remote since March of 2020. So, it's kind of, I did meet Senator Chittenden in person, but I've never met Senator Ingalls in person. It is an odd time. So the best of luck to you in all your endeavors.
Thank you. Thank you to all of you. This visit to your committee is actually personal for me. And I feel like it's a bit of a goodbye, to be honest. So, I might have the opportunity to come back in a different capacity, but I just want to say thank you, because one of the things I said in my comments on being sworn in is that, for me, life has been about lessons learned, and I've learned a lot from each of you. Truly, I have. So thank you for those lessons. I carry them with me.
Thank you. Appreciate it. Judge Zone, thank you for joining us and bringing
Thank you.
Judge Novotny with you. And